I'm waving the flag. We have something to celebrate. Welcome back to Rob's Feed today. This is episode number 67, A Constitutional Right. I'm Rob Schendel. Go ahead, call me a liar. I'm not going to do something I said I was going to do. I lied. Go ahead, that's all right. I was going to talk about Betty White and Cloris Leachman, and I was going to talk about Carol Channing. Wrong. I will, but not today. I have something better to talk about, and when I come back, I'm going to get right to it. Maybe you're a college student living in a dorm. Maybe you just live in a small studio apartment. What you need to do is get over to dormco.com/Rob. Once you're there, you'll find all kinds of items specifically designed for folks living in small spaces. That's dormco.com/Rob. It is Thursday, the 5th of August, 2010. I am going to read you from the New York Times. Until Wednesday, the thousands of same-sex couples who have married did so because a state judge or legislature allowed them to. The nation's most fundamental guarantees of freedom set out in the Constitution were not part of the equation. That has changed with a historic decision by a federal judge in California, Vaughn Walker, that said his state's ban on same-sex marriage violated the 14th Amendment's rights to equal protection and due process of law. The decision, though an instant landmark in American legal history, is more than that. It also is a stirring and eloquently reasoned denunciation of all forms of irrational discrimination, the latest link in a chain of path-breaking decisions that permitted interracial marriages and decriminalized gay sex between consenting adults. As the case heads towards appeals at the circuit level and probably the Supreme Court, Judge Walker's opinion will provide a firm legal foundation that will be difficult for appellate judges to assail. The case was brought by two gay couples who said California's Proposition H, which passed in 2008 with 52% of the vote, discriminated against them by prohibiting same-sex marriage and relegating them to domestic partnerships. The judge easily dismissed the idea that discrimination is permissible if a majority of voters approve it. The referendum's outcome was irrelevant, he said, quoting a 1943 case, because fundamental rights may not be submitted to a vote. Who said that? Who said that this week? Who said that 2 weeks ago? Who said that before? I did. You do not have the populace vote on civil rights. Back to the editorial. He then dismantled brick by crumbling brick the weak case made by supporters of Proposition 8 and laid out the facts presented in testimony. The two witnesses called by the supporters, the state having bowed out of the case, had no credibility, he said, and presented no evidence that same-sex marriage harms society or the institution of marriage. Same-sex couples are identical to opposite-sex couples in their ability to form successful marital unions and raise children, he said. Though procreation is not a necessary goal of marriage, children of same-sex couples will benefit from the stability provided by marriage, as will the state and society. Domestic partnerships confer a second-class status. The discrimination inherent in that second-class status is harmful to gay men and lesbians. These findings of fact will be highly significant as the case winds its way through years of appeals. One of Judge Walker's strongest points was that traditional notions of marriage can no longer be used to justify discrimination, just as gender roles in opposite-sex marriage have changed dramatically over the decades. All marriages are now unions of equals, he wrote, and there is no reason to restrict that equality to straight couples. The exclusion of same-sex couples from marriage exists as an artifact of time when the genders were seen as having distinct roles in society and in marriage. That time has passed. To justify the proposition's inherent discrimination on the basis of sex and sexual orientation, he wrote, there would have to be a compelling state interest in banning same-sex marriage, but no rational basis for discrimination was presented at the 2.5-week trial in January. The real reason for Proposition 8, he wrote, is a moral view, that there is something wrong with same-sex couples, and that is not a permissible reason for legislation. Moral disapproval alone, he wrote, in words that could someday help change history, is an improper basis on which to deny rights to gay men and women. The ideological odd couple who led the case, Ted Olson and David Boies, who fought against each other in the Supreme Court battle over the 2000 election, were criticized by some supporters of same-sex marriages for moving too quickly to the federal courts. Certainly there is no guarantee that the current Supreme Court would uphold Judge Walker's ruling, but there are times when legal opinions help lead public opinions. Just as they did for racial equality in previous decades, the moment has arrived for the federal courts to bestow full equality to millions of gay men and lesbians. Thank you, New York Times. I really do not like to sit here in front of this camera and just read you an article. But in this case, I made the exception. I made a few exceptions in this episode. The New York Times said it so well, I couldn't have done better. I had to repeat it. I had to read it to you. Also, I want to thank the judge, Judge Vaughn Walker of the federal court out there in California. What a brilliant man. I feel so good about this decision. One, my thoughts is I didn't know they were going to be in the decision. I had thought the same thing before. You do not vote on civil rights. You cannot vote on civil rights. I've said that this week. I've said it before. Enough of me. But the opens up gay marriage in a way that decision is so succinct, so well. It's going to be very difficult for a higher court to say, well, that's wrong, because it isn't wrong. Happy days. And on that note, that's all I'm going to say.